Let me invite the Honourable Senior Minister of State to respond to all the comments.
Thank you, sir. Sir, I thank the members for speaking up with their comments and also the various suggestions that have been made. These are very thoughtful, considerate comments, and I'll do my best to respond to them. And I'll do so grouping them into these 5 different topics. The first relates to the consolidation of the personal and corporate restructuring and insolvency laws into one single legislation. It's omnibus, not omnipotent. Second, the new licensing and regulatory regime which regulates all insolvency practitioners. Third, the proofs of debt during winding up. Fourth, the availability of third-party funding in judicial management and liquidation. And finally, the need to safeguard the interests of creditors and employees, a point that Mr. Tay spoke very passionately about. Both Mr. Pillay and Mr. D'Souza commented on the benefits brought about by the bill, which consolidates the personal and corporate insolvency provisions into one. Indeed, having them in a single piece of legislation will bring about greater clarity and access, as well as expediency, cost-effectiveness, and certainty through the reduction of numerous cross-referencing that we now see between the Companies Act and the Bankruptcy Act. I take this opportunity to highlight that the bill also sets out common principles that run across the different regimes where possible. So, for example, Part 9 introduces new provisions that are generally applicable to both judicial management and winding up. Currently, this is given effect to in judicial management and winding up by way of cross-referencing provisions in the Bankruptcy Act. In the bill, these regimes now have provisions specific to themselves, with the necessary refinements to ensure that are worded in a terminology consistent with the JM and the winding up regimes. These include provisions relating to proofs of debt in clauses 218 to 223 and the adjustment of prior transactions in clause 224 to 229. Second, the bill also introduces new provisions for disclaimer of onerous property for judicial management and winding up in clauses 230 to 233 and personal bankruptcy in clauses 373 to 376. In particular, clauses 2304A and 3734A are new provisions that require the judicial manager, liquidator, or official assignee, as the case may be, where the property is subject to any written law under the second schedule, to give notice of the intention to disclaim the property to the relevant regulatory authority. This written notice must be given before the office holder may give notice of disclaimer under clauses 2301 or 3731. This ensures that the relevant regulatory authority has the opportunity to address any issues relating to the property under the relevant environmental legislation. On the new licensing and regulatory regime, a point that both Mr. Tan and Mr. D'Souza spoke about. Mr. D'Souza in particular noted that the new requirements to act as a practitioner are more stringent than the previous ones. To develop and strengthen Singapore as a restructuring forum of choice, a robust licensing and regulatory regime forms an integral and necessary part of that ecosystem. It's necessary to ensure that professional standards are maintained and upheld by all insolvency practitioners. This is also necessary to ensure that only fit and proper persons who are qualified are granted such licenses to allow the licensee to undertake the spectrum of restructuring and insolvency work as described in clause 47.1. Mr. Tan also asked about what it is that the conditions might be that will be specified. If Mr. Tan looks at clause 50, it provides for certain 52, it provides for certain categories of persons who are qualified to act and to administer such insolvencies. And whilst the provisions are being developed, Mr. Tan can take it from me that it will be along the same vein to ensure that the relevant expertise, the proper experience is befit for the person to manage such restructurings and also insolvencies. Mr. D'Souza asked about the purpose in clause 53.2, specifying 30th June as the date on which a valid license that is not renewed would expire, given that the renewal of licenses would all come at the same time. I think that's the point that Mr. D'Souza made. Under clause 50, a qualified person who is eligible to hold an insolvency practitioner's license means any person who is an advocate and solicitor, public accountant, or chartered accountant, or possess such other qualifications as the minister would prescribe. That is in the first three cases, that's really no different from the scenario that we have today in terms of the qualifications. Currently, the registration of a public accountant or chartered accountant is valid from 1st January to 31st December of each year, whilst the practicing certificates of advocates and solicitors run on a different time scale. They're from 1st April to 31st March each year. So the specified date of 30th June provides sufficient time for applicants for an insolvency practitioner's license to produce the required evidence of such registration or practicing certificate. Mr. D'Souza also asked, and I think he said, since a written direction can convert a condition into a criminal offence if the condition is not complied with, what kind of conditions are envisaged that the licensing officer may specify under Clause 52.2? Let me clarify. Clause 58.3 provides that it is the failure to comply with the requirements specified in the written direction issued under Clause 58.1 that constitutes the criminal offence, and not the failure to comply with the condition of the license per se. So one is a criminal offence, which Mr. D'Souza has in mind, and the other is a regulatory breach. Such written direction may require the licensee to comply with or cease the contravention of any provision of Part 3, Division 3, or any condition of the license, or make good any default arising from the contravention, or both. So if there is a contravention, or if there's a non-compliance, the direction would specify that such compliance has to be provided. And it is a subsequent failure to comply with that written direction that constitutes the offence, and not the initial failure to comply with the condition of the license. Second, regarding the type of conditions that is envisaged to be specified, one example would be for the practitioner to comply with all the relevant statutory requirements under the bill. MinLaw will take reference from other professional licensing regimes when formulating the licensing conditions, a point that also responds to Mr. Tan's query. Mr. D'Souza asked, in the context of a winding up, if it is intended for Clause 218 on provability of debts to change its reference point from the making of the winding up order to the making of the application of the winding up. The answer is no. In the case of a winding up pursuant to a court order, the reference point is the making of the winding up order itself. Mr. D'Souza, on a related issue, also referred to Clause 218 2A1 and 2, where the phrase commencement of the JM or winding up is used. A similar phrase, commencement of winding up, is also used at 218.1A1 and 2. And the meaning of those phrases must be ascertained in the context of the provision itself. In other words, the phrase used in this clause are not defined in Part 9, and considering the context of this clause in the manner described above, the plain and ordinary meaning of these words would apply. Meaning. In the context of clauses 224 to 229, where it is intended for a technical meaning to apply, Clause 2171 sets out the definition for that technical meaning, which applies only for the purposes of clauses 224 to 229. Further, Mr. D'Souza also asked if the technical meaning of commencement or winding up in Clause 126 applies to Clause 218 as well. Clause 126 in Part 8, Division 2 applies to applicable provisions in that division, such as Clause 130, which requires the technical meaning provided under Clause 126. The technical meaning in Clause 126 does not apply to Clause 218, which is in Part 9. I turn now to move to Mr. Pillai's comment on how the bill enhances the availability of third-party funding that allows the judicial manager or liquidator to pursue claims against parties on behalf of the company. I had earlier mentioned that a new option which allows the judicial manager or liquidator to assign proceeds from an action set out in those as follows. Currently, the main drawback of Section 328(10), as Mr. Pillai might be aware, was as stated by the Insolvency Law Review Committee, is that, and I quote, the court may make an order only after the relevant assets have been recovered, protected, or preserved, or after the relevant expenses have been recovered. At the point of providing the funds or the indemnity, the funding creditors at that stage will have no assurance that the court will make an order, giving them an advantage over other creditors in consideration. That's a limitation to the current regime in 328(10). To address this, the new provision with Clause 2042 allows the court to make such orders prior to the creditor providing the funding or indemnity. In summary, these two options will increase the availability of third-party funding to facilitate the judicial manager or liquidator pursuing claims against parties on behalf of the company. Next, I think various members spoke up about safeguarding the interests of creditors, and I'll turn to this point now. Mr. Pillay in particular commented that there is a need to balance the interests of creditors against that of companies, and I agree entirely. I would like to assure Mr. Pillay that the overall regime will continue to balance the interests of all stakeholders carefully, including creditors, whilst strengthening Singapore as a forum of choice for debt restructuring. Specifically, in relation to Mr. Pillay's query on how the balance between a financial centre and being an international centre for debt restructuring should be struck, I should say that these two objectives are not mutually exclusive. In fact, in many ways they are complementary. We want businesses to be set up here, thrive, function, operate, but when they fall into difficult times, given the impact it has on various stakeholders in terms of the creditors, employees and other counterparties, we want to provide them the best possible tools and the best regime possible in this forum to restructure and get back on its feet. Being an international centre for debt restructuring, in fact, augments our attractiveness as a global financial centre, therefore. It enhances our capabilities to provide comprehensive end-to-end suite of options for businesses and transactions. I turn now to the ipso facto clauses, which I think several members spoke on 440. Both Mr. D'Souza and Mr. Pillay commented on the potential consequences of clause 440 in exposing creditors to a greater risk and uncertainty, and have asked how it is calibrated to address these consequences and balance the different considerations. To start, let me reiterate the reasons for introducing the restriction. And Mr. Pillay is right. He's read both of the committee's reports. Both committees obviously had the ipso facto provision before it, but at that stage chose not to recommend it as being one of the options. That's why it didn't make it into the 2017 amendments. But the restriction that we have in mind in clause 440 supports a company's restructuring efforts. It prevents the other party to the contract from unilaterally exercising his or her rights against a company to terminate or modify the contract solely because of the commencement of restructuring proceedings. In other words, solely when a company applies to court or voluntarily takes a restructuring step. It is in that limited scenario that the ipso facto clauses are being sought to be restricted. Such actions undermine the prospects of achieving a successful restructuring. As Mr. D'Souza has pointed out, having this restriction will give the company necessary time and room to restructure by protecting the company's valuable commercial contracts from termination or modification. In other words, if one is about to restructure and get the company back onto its feet, the last thing it wants is for valuable counterparty contracts to be terminated for no reason other than that it is now sought protection from the courts. These restrictions allow a company to continue with the key commercial contracts to generate revenue, or which enable the company to continue operations itself, and thus preserving and enhancing the value of the company itself. Take the example of Hyflux, a recent case. Shortly after filing for a moratorium under the current regime to support its restructuring proceedings, certain creditors declared an event of default had occurred because of the moratorium filing. So no other breach of that underlying provision, but because of Hyflux's filing of the moratorium protection and an application to court to protect and enhance its restructuring efforts. Based on this event of default, the creditors exercised the contractual rights, such as the acceleration of payment terms and set-off rights in respect of debts owing by the creditor to Hyflux. So the moment that happened, some creditors exercising contractual rights like the ipso facto provisions provided for accelerated repayments to be made when it was otherwise not yet due, or provided for a set of rights that they could then exercise immediately. So all of these steps diminish and restrict Hyflux's cash flow. And that's not an untypical situation that happens. And this thereby further exacerbated the financial position of the company. Now, if a similar situation arises in the future, Clause 440 would restrict creditors from exercising such rights solely on the basis of the filing of a restructuring moratorium. This would allow the company to continue with its business operations while restructuring its debts, provided there are no other events of default which are triggered outside the scope of 440. As Mr. Pillay noted, a successful restructuring benefits its creditors as it preserves the ongoing value of a company. I would go beyond that to say that a successful restructuring will in fact maximize the benefits of the company stakeholders, or to the company stakeholders as a whole, including, as Mr. Tay knows, its employees and also its trading counterparties. Finally, the introduction of such a restriction would also align Singapore with key jurisdictions such as the US, Canada and Australia, which do offer debtor companies seeking to restructure their business interests such similar forms of protection. Although the Insolvency Law Reform Committee had not recommended at that time restricting ipso facto clauses in its report, this was about 5 years ago. This amendment is now being introduced because of further industry feedback, which continued after both committees had completed their work. And the feedback received would be that such restriction on balance would be beneficial to the company's rehabilitation efforts. Having said that, my ministry is mindful that the restriction on the operation of such clauses must also balance the interests of all stakeholders, including the counterparties. And what has been done is to calibrate 440 as well, to introduce the ability to deal with different considerations. And I wish to just highlight and reiterate the following notable features. First, the restriction is suspensory in nature, meaning it is only for the duration of the period when the company is embarked on and continues the restructuring proceedings. So from the time it commences until the time it gets out of the restructuring proceedings, either successfully or unsuccessfully. It does not seek to terminate or extinguish the other party's contractual rights. So there's no change in the rights altogether. It's only suspended during a period of time. Second, the scope of this restriction is limited. The exercise of contractual rights is only restricted if restructuring proceedings are commenced or the company is insolvent. The creditors may still exercise their rights where there is another contractual ground to terminate the contract. So, in the example that Mr. Pillay spoke about, the securities company would be entitled to terminate the margin facilities where the company has failed to maintain sufficient collateral with the securities company if this is otherwise a contractually provided for ground for termination. Third, Clause 4405 provides that the restriction does not apply in respect of any legal rights under the types of contracts set out in that paragraph. These exemptions reflect the fact that there are situations where the restriction of such clauses may have a disproportionately adverse impact on markets and also introduce uncertainty into markets which depend on an established system and norms. I think Mr. Pillay did speak on certain classes of financial contracts that will be eligible for such exemption and the scope of the exemption. We will work with the relevant holders to ensure that the prescribed exemptions will strike the appropriate balance amongst the interests of stakeholders. The exemptions will only be finalized after we have obtained and studied feedback from stakeholders, as well as the experience in other jurisdictions who have introduced the ipso facto restrictions ahead of us. At this juncture, I can say that it is likely that the definition of eligible financial contracts that will be exempted would include repurchase agreements, swap agreements, and forward contracts, which is similar to the position in the US. To the extent that certain contracts will fall within the exemption as an eligible financial contract, this will ameliorate any potential negative impact on the industries that rely on such contracts for various commercial reasons. This includes, no doubt, the wealth management industry that Mr. Pillay spoke about, which is also an industry that we will consider as we take feedback on what would constitute an eligible financial contract. Next, Clause 4404 contains a further safeguard for creditors by allowing any affected creditor to apply to court on the basis of significant financial hardship. This builds in a degree of flexibility depending on the impact that it may have on a particular situation or on a particular creditor, and this can be determined by the court on the basis of the facts in that case, the context in that case, and on a case-by-case basis. As highlighted above, whilst the bill facilitates the rehabilitation of distressed companies, we have taken efforts to ensure that the overall regime does strike a sufficient balance to ensure that the interests of all stakeholders in this ecosystem is fair and balanced. Moving forward, we will continue to study developments both locally and also abroad so as to ensure that the regime continues to balance the interests of all stakeholders. Next, I turn to the point Mr. D'Souza raised about 3274, Clause 3274, which requires a secured creditor to notify the official assignee within 30 days after the date of the bankruptcy order of the intention to claim interest on the secured creditor's debt. Mr. D'Souza expressed some concern that such a requirement might be prejudicial to a secured creditor's interest and asked if there are safeguards in place. I would like to emphasize that this provision only affects the secured creditor's entitlement to any interest in respect of the secured creditor's debt after the making of the bankruptcy order. So it's for a period of time post the making of the bankruptcy order. To avoid doubt, this does not in any way affect the secured creditor's interest, his security interest. The intention of this change is, as Mr. D'Souza mentioned, to facilitate a more efficient administration of the bankruptcy by ensuring all stakeholders, including the official assignee, that they are all on the same page with respect to the bankrupt's total liabilities and consequently the value of the assets in the bankrupt's estate that would be available for distribution. In addition, the subsidiary legislation under the Bankruptcy Act currently already requires a bankruptcy order to be gazetted and advertised no later than 21 days after the bankruptcy order is made. A notice requirement will likely be reenacted in the subsidiary legislation under this bill. These requirements ensure that sufficient notice is provided to all stakeholders, including secured creditors. Secured creditors would thus be notified of a bankruptcy order and in turn allow the secured creditor to notify the official assignee of the intention to claim an interest under Clause 3274. I now want to move on to Mr. Tay's points, his very passionate points on the interests of the employees, a point that Mr. Tay has raised several times, and I'd like to turn to those points now. Essentially, Mr. Tay's points focus on the need to protect the employees' claims for unpaid salaries in the context of an insolvency. And Mr. Tay touched on this issue, I think, in two different scenarios. The first, where a company is in a restructuring proceeding, and second, when the company is in a liquidation proceeding. And the difference between those two is obviously in a liquidation scenario, it is terminal. There is one outcome. The approach and treatment of such claims under those situations are different, consequently, with good reasons for this. In a restructuring situation, such as in a JM, the impetus is to facilitate the company restructuring its debts and hopefully rehabilitate its business to its former position or better. For there to be a meaningful rehabilitation, employees are an important group of stakeholders. Mr. Tay mentioned this, and I agree. Workers are the lifeblood of the company, and in times of difficulty, the company stands little chance of rehabilitation without its workers. I agree with that. Given that there are various types of debts incurred during the course of judicial management, including employees' wages, Clause 114 contains new provisions that clearly provide for the priority of such a debt incurred by the JM on behalf of the company ahead of other expenses incurred, or the remuneration of the judicial manager. Under this new provision, employees' wages that are incurred in the course of judicial management would fall under Clause 1141B as, and I quote, any sums payable in respect of any debts or liabilities of the company incurred during judicial management. This will rank second in the order of priority behind only any super priority debt arising from rescue financing obtained pursuant to an order under Clause 101(1)(b). Such super priority rescue financing is integral and fundamental in most corporate restructuring cases. New money and injection of new capital is really the lifeblood of a successful restructuring. And without the injection of rescue financing to aid the company during the restructuring process, the restructuring may not get off the ground. Therefore, any potential prejudice to employees, which Mr. Tay mentions, must be balanced against the benefits of a successful restructuring, such as the potential continuation of employment and a higher rate of repayment of outstanding wages as compared to a scenario where the company goes into liquidation. Mr. Tay mentioned the grant of super priority rescue financing cases under Clause 67 and 101 and whether they are subject to safeguards. And in particular, Mr. Tay mentioned the case of Restructuring Group Limited, a 2017 decision of the High Court. The courts would generally be slow to allow super priority financing unless it is strictly necessary. That said, as I mentioned, given that new monies and new injection of capital, and in some cases, super priority funding, in the appropriate circumstances, it will be allowed as well. I turn now to a scenario where employees' wages are not paid in an insolvent liquidation scenario. As I mentioned earlier, this procedure is terminal. It leads to the dissolution of the company. And it is so because there are insufficient assets to meet the myriad of competing creditors' claims. In this context, the order of priority provided under Clause 203 strikes the appropriate balance in according such priority, taking into consideration the nature of the varying claims against the company. The costs and expenses of liquidation and expenses of the applicant for the winding up order are paid out first under 2031A to C before any of the other preferential debts under 2031, point that Mr. Tay mentioned earlier. Removing the priority for these categories of claims would deter insolvency practitioners from undertaking liquidations because they would have little assurance of recovering the costs and expenses of such liquidations. This would severely undermine an orderly liquidation and distribution of dividends to the detriment of all stakeholders, including employees. So we are dealing with the cost and expenses of undertaking the liquidation in the first place. Now, Mr. Tay then mentions that because of the provisions, what used to be a rank number 2 for the employees' claims is now ranked number 4. Let me deal with that. Immediately after the preferential debts mentioned in 2031A to C, Clauses 2031D and E provide that employees' claims enjoy the next highest priority as between all the preferential debts of the company in liquidation. This clearly and unequivocally affirms the importance of employees by providing such debts priority over all other lower-ranked preferential debts and all other unsecured debts. Mr. Tay mentions that whereas currently employees' wages are ranked second under 321B, is what you have in mind, of the Companies Act, Clause 2031D, however, provides that the unpaid wages are ranked fourth amongst preferential debts. Let me clarify that the new 2031 has no material impact on the relative priority. That is because the debts mentioned under the new Clause 2031A to C are currently placed together under 321A. So in other words, 321A, or what went into 321A, would be 203A, B, and C. So what 203 has sought to do is to break up what otherwise used to be a group of priority or preferential claims, all of which already ranked ahead of employees' wages, and parcel them out into 3 separate portions to deal with it in A, B, and C of 2031. Those debts that were previously under 3281A have been set out in those 3 provisions, as I mentioned, and there is therefore no change from the existing position under 3281 in relation to the relative position of the employees' claims. Lastly, Mr. Tay asked for some statistics. They are not available, but I thank Mr. Tay and also I think Mr. Tan for raising some suggestions on the avenues. Mr. Tay, I think, also talked about having the MOM make those claims first and then to stand in queue. I think that's probably better addressed to MOM because it's a burden you're asking them to take on and then wait in queue for the claims. But Mr. Tay has our assurance that the structure of the preferential payments will continue to place the employees high up on the scale and behind really only the provisions that deal with expenses of the liquidation, so that we can be assured that the liquidation will be properly proceeded with and prosecuted. I want to deal with a couple of points raised by Mr. Tan as well, and I think Mr. Tan asked me about the rehabilitative framework, the differentiated discharge framework. The scheme came into force on 1st August 2016, and at present it is still somewhat early to comment on the impact of the scheme, because bankrupts whose bankruptcies commenced after the amendments came into force will only begin to be eligible for discharge in 2019. To date, we have not commence any studies on whether the DDF objectives have been met or otherwise, as the scheme, given what I've said earlier, is still new. But I thank Mr. Tan for that suggestion, and certainly will look into studying the impact of the DDF at the appropriate time when more data becomes available and there's a greater runway after the implementation itself. I think Mr. Tan also asked about what has been the type of typical misconduct cases in the past 10 years or so. Typically, when you appoint an insolvency practitioner, you are looking for the level of professionalism that is commensurate with what you might see from an advocate solicitor, chartered accountant, or a public accountant. So those are the criteria we've set out. And as I said earlier, the prescribing criteria will largely follow the same lines. On the types of misconduct in cases, we've looked up some. I think Mr. Tan might be familiar with some because they've been reported in the law reports. One example would be Mr. Yu Pang Kui. Mr. Yu was a public accountant. He acted as a liquidator for 21 companies, and he was on trial earlier this year for allegedly pocketing more than $40 million from those companies. Not that having the new licensing regime or having a set of rules would necessarily mean that there will be no fraud. But what we want to do is to ensure that the bar or the barrier is higher so that there will be proper regulation just for insolvency practitioners, and that we avoid the type of conflicts that we see as in Mr. Yu's case, which may well be an extreme example, but we also want to ensure that other professional misconduct type cases, like acting in conflict of interest or having unnecessarily high remuneration, can be something that will be controlled. So those are some of the examples. Mr. Speaker, I just wish to conclude now by making the point that we've come some way, as speakers have mentioned, since the two committees sat. And to recap, in 2015, significant amendments were made to the Bankruptcy Act, including the introduction of the DDF, which gave bankrupts a clear target to work towards in order to be eligible for discharge. This promoted a more rehabilitative regime where bankrupts would be given a chance to start over again. Changes were also made to require institutional creditors to appoint private trustees in bankruptcy when making a bankruptcy application. This change encouraged greater engagement by such creditors in the insolvency process and drives such creditors to exercise greater financial prudence when granting credit. In 2017, the amendments to the Companies Act introduced new features to strengthen the schemes of arrangement and judicial management regimes. This put in place a bespoke debt restructuring regime that incorporated the best features of the world's leading regimes. And these features included a super priority for rescue financing in schemes of arrangement and JM to encourage injection of fresh funds to assist the debtor through restructuring processes. 2, enhanced moratoriums in schemes of arrangement to provide breathing room to the debtor that is seeking compromise or arrangement with his creditors. 3, pre-packaged schemes of arrangement to fast-track pre-negotiated restructuring plans. And 4, the cram-down provisions that prevent a minority class of creditors from preventing a restructuring which has otherwise the support of a majority of its creditors. Mr. Tan asked for an indication of how successful this has been. As I mentioned at my opening speech, we had about 100 applications made following the amendments in 2017. We have put the tools in place for this to be successful as an international restructuring regime. So we have used UNCITRAL, which is a cross-border mechanism. We have the GIN, Judicial Insolvency Network, where courts in Singapore can now, in real time, link up with and also speak with courts of other jurisdictions. And so far, the US, Korea, and Australia have been jurisdictions that have signed up to this scheme. And that allows our courts here to be very global and very cross-border in the kind of work, kind of cases that they see. And finally, you also heard me say that the Supreme Court has also signed up with the US courts on 2 MOUs, which would cement that relationship and also take the platform on which such cases can appear or be heard in Singapore that much further. This bill is the culmination of concerted effort undertaken by the government and other stakeholders in the insolvency ecosystem to transform and modernize our insolvency regime. And that is with a view to cementing Singapore's position as a forum of choice for debt restructuring. The bill also harmonizes the different provisions from the Bankruptcy Act and the Companies Act, including the earlier amendments that have been made into a single statute. Management by resolution of creditors, and a new restriction on the operation of ipso facto clauses. These modern and progressive reforms signal our ambitions to become an international center for debt restructuring. We have achieved quite remarkable progress on the various legislative reforms on this topic over the past 3 years or so. My ministry will continue to work and ensure that the legal regime remains balanced, robust, and perhaps importantly responsive to the needs of the stakeholders in the system, be it debtors, creditors or other stakeholders. Beyond the legal regime, we will continue to develop and enhance Singapore's ecosystem for restructuring and insolvency so that Singapore remains efficient, effective and consistent in achieving outcomes that are in the interest of all stakeholders. I would add in closing that all of this has really only been possible because of the efforts of all the stakeholders, all the people we've consulted, the feedback we've received, maintaining and extending those existing partnerships, and fostering new collaborations as we continue to build on bold and exciting developments. I conclude by thanking the members for their suggestions. Those that I have addressed, I've addressed today. Those that we have not yet been in a position to deal with, I've taken on board and will continue to monitor them as we look at refining this in the near future. Sir, with that, I beg to move.
The question is that the bill be now read a second time. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it.
Insolvency, Restructuring and Dissolution Bill.
SMS committee stage what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve. The question is that clauses 1 to 527 stand part of the bill. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that the first to third schedules stand part of the bill. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. Bill to be reported. Senior Minister of State for Law.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of the opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it.
Insolvency, Restructuring and Dissolution Bill.